welcome to 3PB's Family Law Brunch. So I'm very excited to introduce you to our first speaker, Laura Buchan. She is a family law practitioner, has a very busy practice in financial remedies and private children law. Laura was called in 2016, and within her financial remedies practice, she has come to specialise in the very novel area of the world of cryptocurrency, something I know nothing about and very excited to hear about today. She's dealt with cases from as little as hundreds of pounds all the way up to millions. And it's her hope that she can provide some quick tips and tricks for you today in navigating these tricky assets. So I'll pass on to Laura. Thank you very much.
Thank you, Rachel. There's quite a lot to go through in the world of crypto, so I'm going to try and compress this into 25 minutes. I'll do my best not to run over. But really, in terms of starting, I thought it'd be useful in terms of everybody's experience here. I'd imagine we've got a range of people that have dealt with crypto assets in financial remedies to people that don't really know what crypto is and here to really kind of learn the basics. So a bit of background about crypto. Everybody has probably come to terms with Bitcoin and has heard of that. That came to fruition some time ago in 2008. And I think when we look at where we are today from 2008, I always think it's fascinating to think that back in 2008, you could buy two Papa John pizzas for 10,000 Bitcoin. And just to put that slightly into perspective, from mid-July, one Bitcoin was worth £88,377. And as of about 9:30 this morning, one Bitcoin had dropped down to 69,244. But certainly, I think slightly soul crushing to think that you could have spent 10,000 Bitcoin on two of those pizzas back in the day. But a couple of, as I say, tips and tricks from me. One of the things I wanted to talk about in terms of Bitcoin whilst we're discussing it is to be aware that there are a number of different cryptocurrencies, and we're going to look at crypto assets as well as different cryptocurrencies. But there are subsidiaries to Bitcoin, and a couple of examples are Bitcoin SV, Bitcoin Cash, and Wrapped Bitcoin. Now, I have had clients thinking that they've got hundreds of thousands of pounds of Bitcoin, to have to pass the very sad news on that actually they don't have Bitcoin. They have got one of these subsidiaries which is worth significantly less. I think, as everybody is probably aware, the volatility of this type of asset is significant. It can go up and down, and that example I've given for Bitcoin just goes to show what is the front runner. Within a couple of months, the volatility is significant. In 2024, just to look at where we've come and where we are now, the Law Society said that there are almost as many definitions of cryptocurrency as there are different types of cryptocurrencies themselves. And these crypto assets form into subcategorizations, and we're going to be talking about these digital assets and other examples of those, such as stable coins and non-fungible tokens, during this talk. But from 2021, there was a record of about 9,000 cryptocurrencies in circulation, and that had a market capitalization of around £1 trillion worth. Fast forward to today, and there are around about 17,100 cryptocurrencies, with an increased value of 1.32 trillion. So we really can see the trajectory of the use of crypto assets, and certainly younger generations using this effectively akin to the traditional stocks and shares market. A couple of points, we're going to talk about some terminology for you as well, but as I say, there's wild fluctuations in this type of an asset, and they're often described as bull runs. So when there is an upward trajectory in the value of a crypto asset, and bear runs when there is a downward trend. So effectively at the moment, Bitcoin is on a bear run. Another example, because we hear lots about Bitcoin, is Ethereum. At the moment, that's one of the second front runners in terms of the crypto asset market. And to put that into perspective, when Ethereum was set up, which was some years after Bitcoin in 2015, one Ethereum coin was worth 46p. As of about 9:30 this morning, one Ethereum is worth £2,291. So you think if you were investing back in 2015, you are absolutely quids in right now in terms of the value of your Ethereum holding. But that also brings me on to how you hold crypto in the sense of you don't have to hold one whole Bitcoin. You can hold portions of Bitcoin, so zero point 0.2, 0.3, and so forth, of the crypto assets themselves, particularly the larger cryptocurrencies. Now, another bit of background for us is we may well have seen and be aware that crypto assets are also commonly linked or promoted or endorsed by celebrities. And an example of that is Elon Musk with the Dogecoin some time ago. He has promoted that previously, and in fact, historically, you used to be able to purchase Tesla merchandise through their website with Dogecoin itself. And more recently, we can see pop stars such as Iggy Azalea that's become involved in the market. Another subcategory I wanted to warn people about, and it is more up and coming, but I have recently had a case that's dealt with it, is meme coins. Now, it's a volatile market in of itself, and I didn't think I'd ever be coming to you to say, well, this is actually even more volatile than your Bitcoin and your Ethereum, your more traditional, if we can put it that way, type of assets. As it really says on the tin, meme coin is effectively blending internet culture with cryptocurrency, embracing humor, showcasing comics around the world, and effectively combining social media and what's going on in that space with the crypto market. Now, these type of assets, just as culture does, it changes. 1 minute we're talking about who's winning the jungle, and next obviously we're talking about the budget and the memes that are recording around that. So they skyrocket and crash just as quickly as these fads do in real life. But turning to how does cryptocurrency work? I can see we've got a lot of participants that may well have been, certainly when I entered this space, that was me pulling my hair out thinking, gosh, I've got a client that has got tens of £1,000s, all the way up to millions in crypto. What does that mean? How does it work? Now, I'm not going to use the time today talking through how blockchain technology works, what we have to deal with. I'm going to really extract the core pieces that we need to know as financial remedy practitioners. But in addition to the slides that you will receive, I also have a handout that sets out quite in depth about blockchain technology, how it works, in case you want to kind of understand a little bit more about the background of how this functions. So won't be exploring that in too much depth today, other than to make some obvious points in that this is obviously an unregulated asset. There aren't any central banks in the UK that deal with this, and it's a digital asset. The blockchain, as I have referred to, it's effectively a code. It's stored within a digital wallet, and that blockchain effectively makes up what the crypto is. They're time stamped and is recorded on a ledger. Now, that blockchain, this is where what we need to know importantly as practitioners, is made up of two different types of code. We have a public key and a private key. Now, I have had some questions in advance of my talk, and I've hoped to weave those questions in, but quite a few of those were around questionnaires, what do we ask for? And I'm going to be diving into that in due course. But what I really want everybody to make a note of is the difference between the two. A public key, if you think of that as the long number on a bank card, and your private key is your PIN code, you're never going to be asking somebody in the questionnaire for their PIN code for their card, so don't ask for their private key for their crypto assets. It's the public key that you want. And I will be giving you a couple of examples where that public key has significantly opened up non-disclosure in some of my cases that I have had and come across. Now, the other type of factor I want you to understand and know about really in terms of the mechanics of how cryptocurrency works is that they can be stored simplistically in two different types of ways: hot wallets and cold wallets. Now, hot wallets are effectively stored online on digital platforms, on trading platforms, and they are accessed through that database and that trading platform. A cold wallet, think of it as offline, and that can be stored on the hard drive of a device, on a USB stick, on an external hard drive, effectively offline. And there's an important distinction there, again, which we'll come on to in a moment. In terms of, again, just an overview of a background, I wanted to let you know that there has been some discussions with the FCA, and as of November last year, there's been a roadmap for regulating this type of asset. That's another attachment that you'll receive in my little crypto bundle that you receive in due course. But a couple of things that they plan to, effectively, they want to do is classify certain crypto assets and as activities regulated by the Financial Services and Markets Act 2000. And there's new tax information rules, and they plan, and I'm going to talk to you about tax because, again, that's important for us as practitioners in our world. But what they plan to do and hope to do is that individuals will need to prove identifying details about their crypto asset service providers. The information is then linked to that person's tax record, and crypto asset service providers will need to provide more information from more of a business perspective. All hopes at the moment, hoping to come into place as of January next year. We shall see if they're on target for that, but I'll give you that roadmap again. In terms of talking about hot wallets and the platforms that they run on, a number of digital exchanges, just by way of example, you've got Kraken, Coinbase, CoinGecko, Binance. Some of you may well have been aware of a couple of years ago, the FTX platform that went into bankruptcy and caused all sorts of difficulties, especially largely out in the States for persons that were holding their crypto assets on that platform. Now, I mentioned a moment ago, I think for our world, more laypersons are using hot wallets because they're easily accessible, able to trade more rapidly. But don't close your minds off to cold wallets. Is there information stored on, or holdings even stored on, somebody's laptop and USBs? I mentioned non-fungible tokens, and again, you might be pulling your hair out to say, gosh, I'm just getting myself around cryptocurrencies. What on earth is a non-fungible token? Without diving into what that is from an IT perspective, I like to think of it, again, that comparative to public keys and private keys, trying to place that to a comparative of the bank card, as the example I used earlier. Think of NFTs have regularly been used as almost a form of digital artwork. So there's been collectibles. Many celebrities have been associated with NFTs, and effectively it's as I say, an online piece of art that's a collectible. And that ranges from singers, sports persons, film stars. And really, it's the real digital version of real world art, because there's a particular code that's associated with that particular NFT, effectively meaning that it's one and done. You can't have copies of it in the sense of the code behind the image. Just by way of as example, previously Madonna spent about 466,000 on dollars, that is, on a Bored Ape NFT, and I wasn't able to obviously insert that within my slide for you to see what that looks like, but you may well want to have a little Google because it's easily accessible. A lot of money on an NFT. So again, another element that we can't overlook. And again, really to make it very clear to everybody here, this is not going away. Crypto assets are not moving in a backwards trajectory. They are moving forwards. And an example of that was in 2022, the FCA reported about 2.3 million people as holding crypto assets. As of 2025, that's gone up to 7 million. And one can only assume that that's going to continue to increase. Terminology, as I say, you'll get all of these slides, but I wanted to just make them readily available for you. I've taken you through the top two there, bull runs and bear runs. Payments exchange tokens, this is largely cryptocurrency, and the blockchain behind that, as well as the cold wallet and cold storage, and hot wallet again as well. We also have some other terminologies, again, just here for you. I'm not going to dive into those in detail because I could be here for a very long time talking about this topic, and we simply just don't have the time. But you've got other elements there, such as public key, mining, which is the process of effectively creating crypto, and the digital coin elements. We've talked about private keys, and stable coins is something that we'll talk about as our block explorers. So really what I think everybody's here for today is what does that mean in our world? Where do we have to consider crypto, and how does the court see it? It is considered as property. The case law there makes it clear, as in the Ainsworth case, definable, identifiable, capable in their nature of assumptions, and having some degree of permanence. The latter probably being the loosest of these strings in terms of it obviously being a digital, non-tangible asset. Now, the consequence of that, quite helpfully for us, means that a number of orders, as it's been deemed as property rather than income, it is considered that we can make a number of different orders in respect of it. And we'll come on to making sure that the element of non-disclosure is equally as important under Section 25 in particular in respect of these assets. There is also a Property Digital Assets Bill 2024 that's looking to come into place. That again sets up clarification in terms of how the cryptos are held. It doesn't deal with every single element, but really, since this case in 2019, there is more and more coming forward by way of bills and case law that demonstrates that the courts are readily and often considering this type of asset as property. A case that we will talk about briefly that isn't on my slide there is the case of Deloy and a Persons Unknown 2022. And that particular case, the crypto asset was Tether cryptocurrency, and that was treated as property. So again, whilst that's in the more commercial space that we're seeing a lot of this case law, it's applicable in our world. I promised you the joys of tax. What is it that we need to know about? And again, I could talk for some time about the different types of tokens and the tax implications on them. However, just to assist, again, one of the other bits of your bundle will be an HMRC manual that effectively identifies the 4 different types of crypto assets. We have exchange tokens, utility tokens, and I'm going to flip through this slide because the 2 that we're really concerned with are exchange tokens, which are the cryptocurrencies and the Bitcoin. And moving on, more regularly we see in our world are then number 4 stable coins. I wanted you to see the 4 different categories that HMRC break them up into. But as I say, exchange tokens and stable coins are the ones that we are more concerned with. I think I've explained exchange tokens, cryptocurrencies, and Bitcoin and the like, and Tether and Ethereum. Stablecoins are really kind of as they say on the tin, a token that's pegged to a stable value, such as a currency or a metal. So one stable coin equals £1. And an example that has recently come out is the coin XRP, which is Ripple. They've created a stable coin that effectively is linked in with the dollar. And there was also some discussions prior to COVID, albeit I don't think that's been picked, the mantle's not been picked back up yet, that in fact the Royal Mint was going to create some form of stable coin as well. So whilst we're not there in the UK in terms of regularly having these stable coins to be able to use regularly as cash equivalents, there has been discussions, and I can only imagine that those discussions will continue throughout the future. But effectively, those are the 2 that we really need to talk about. So if we have a Ethereum owner, someone walks into your office with Ethereum and says, right, this is what I've got £2,500 worth of Ethereum. CGT, one of the first things we all need to be thinking about, what was it worth and how much did you spend on it when you bought it? What is it worth now? Because this is the tax that's going to bite for our clients in financial remedies, and when we're looking to distribute and deal with it in terms of computation and what type of orders we're going to be seeking. Because of course, if you're transferring, that's going to be relevant, or sale, that's got to be factored in. Can't just be using an artificial, well, it's worth £3,000. It was bought at 200 and then nobody's factored in the CGT that's going to come off of that, because that's clearly wouldn't be a fair computation. So we have to look at that. That is the most common type of tax that we will come across. Again, I'm not going to dive into the world of mining. There are some exceptions, and I wanted to point them to you in my talk. If you have a client that is particularly in the IT world and they are mining or staking, so effectively creating that and generating, that can be seen as an income, and income tax can apply to it. It's going to be the rarity in that sense. And interestingly, the third, of course, is inheritance tax. Now, I have actually had a case where a client has inherited crypto, and that had to be factored in terms of the asset itself. But most regularly, we'll be looking at CGT. The position in terms of businesses, as I say, I just wanted to flag is we are seeing more and more companies holding, as if when we're looking at the business assets, holding crypto assets as part of the company. And again, that's something that we're going to have to factor in that sense. Or, as interestingly, I have had on a matter where somebody has been paid bonuses by way of their crypto holdings. So again, one of the take homes I'm going to be saying, and I'm going to be talking about questionnaires. Don't be afraid to ask a question. If something doesn't look right on a payslip, ask the question. Now, for me, is it fit for purpose? I think we have all got different reasons for our views on this, but what I would say, I'm just going to focus on the crypto element. I said before that the fact that it's dealt with property, this type of asset, means that under Section 24 of the MCA, property adjustment orders can be made, all sorts of orders that are within the court's remit. So we must make sure if there's been non-compliance, Section 25 2G bites, and that needs to be factored in. But for me, one of my pet peeves as somebody that deals with crypto is when you receive a for me that effectively gives more questions than answers. A cryptocurrency, £1,000 that's put into effectively the investment column, because at the moment, really that's the only place that it can be served. I've provided here a couple of things that you need to be thinking about, both when you have your client that comes in with the crypto, but also when you're on the other side. So when you're thinking about filling in that for me, what cryptocurrency is held? Don't just put cryptocurrency because it's as helpful as a chocolate teapot to everybody. Is it Ethereum? Is it Polkadot? What value, what's the volume of it? What was the value at purchase? What is it worth now? Is it stored in a hot wallet on an online platform, or is it stored in a device cold wallet? Is it in their sole name? Is it associated with another person? Does another person have access to that wallet? And are there any other crypto assets? So do they have NFT holdings or collectibles as well? Now, questionnaires. This is the big one. I had lots of questions from you about, well, what questions do we ask? So using, for example, the useless for me analogy I just said, so crypto of £2,000. As we've talked about, what type of crypto asset is held? Is it an exchange token? Which token? Can you confirm the cryptocurrency that's held? What was the purchase price? What's the current value? Please provide documentary evidence, which I'll come on to in a moment. What are the trading platforms? Now, just be aware that just because somebody has a Coinbase platform doesn't mean that they don't also have a Kraken platform. So make sure every single type of hot wallet has been provided on their online holdings. I had a case of mine where I was dealing with the wife trying to go through the husband's asset basis, and he had 13 different hot wallets, which we were able to locate, and some of them weren't disclosed, which I'll come on to briefly at the end of this talk. Now, always make sure that you have an overarching question. If somebody says they've got Bitcoin, make sure that you ask, are there any other holdings that you have, any other type of cryptocurrencies that are held in your name, or crypto assets, the NFTs, making sure that you have those sweeping questions to cover everything. It's really, really important, because if you don't ask the right questions, you won't get the right answers. Another point I wanted to talk about, which is for FDA directions and how you manage receiving the answers to your questionnaires, because I think that's just as important as asking the right questions. Now, at FDA, I have quite commonly, hopefully, you're in a position where you know whether you're going to be demanding some form of order for somebody's device to be analysed because they hold things on a cold wallet. You can ask for the directions, standard directions around the crypto. But it might also be useful, and I've quite regularly started to insert within the generic updating disclosure template, updating evidence in respect of the crypto. Now, that could be screenshots of their hot wallets, their crypto holdings. That needs to make sure it's time marked, it's dated, so you know that it's accurate. And I'm going to give you some other tools to be able to check, because in our world, we never trust anybody of what they say at first time around. And making sure that when you're making without prejudice offers, you have got the most up to date. And there has been times where I've asked for updating disclosure, which is 4 weeks prior to the FDR, and then seeking a direction for a short confirmation 7 days prior to exchange of without prejudice, because the volatility of this asset, you need to make sure that you have, when computation is being looked at, the right figures. And I'm certainly the type of counsel that will bowl up at an FDR, and having looked at coinstats.app, which is going to be one of the invaluable pieces of the puzzle that I'll give you, where you can check what the rates are, and almost buy in 5 minute increments, and they go all the way back through until when the asset was first created, which is how I know Ethereum, for example, was only 46p in 2015. One of the important things is blockchain explorers. Now, it probably feels like a bit of a mouthful. There are lots and lots of different types of blockchain explorers. The public key that you receive, you can effectively put it into these explorers, and it creates the ledger. The use of showing where exchanges have happened, to which other public key a crypto asset has been sold to, and you can follow the money. Now, whilst we're not financial advisors, and obviously we are not forensic accountants in of ourselves, there is a method behind the madness. And I'm going to give you about 5 or 6 in my handout, and they can be, Soloscan is one, Blockchain Explorer, Blockchair, Etherscan for the Ethereum. There's a lot, and actually that particular combination of scans actually led to me being able to find, on a conference I was instructed on, it was disclosed as there being about 50,000 worth of crypto, and we were able to follow the public keys to actually show that some six months prior to us starting the pre-litigation process, he had sold over £1 million worth of Solana. So again, you can do that exercise. It's not easy, it's clunky, it takes a bit of time, but there are ways for us to be able to fact check people. If this is a really complex case, then of course the forensic accountants need to come in, and chain analysis, elliptic, and cipher trace are just 3 examples that I have used previously. Now, I've just given a couple of pieces of case law here. These are commercial cases and the large in respect of crypto. Everybody has probably heard about the Welsh landfill story a couple of years ago, that effectively if you lose it, tough. The same applies if you lose your private key and you can't then access, even if you think you've been hacked, for example. Tulip Trading an example of that. It is your responsibility to continue to maintain that private key and make sure you're looking after and remembering, if that laptop, as in the Welsh landfill case did, remembering that it held millions of pounds worth of crypto. But in terms of freezing injunctions, I was asked about enforcement. Now, this is probably the trickiest element of crypto assets in our world. The case of Deloya that I've talked about earlier is really useful, because it goes to show that courts do not shy away from, just because the third party is unknown in the jurisdiction, that freezing injunctions won't be made. There are ways that we can talk about that, and that may well be an element that we have to explore under enforcement elements to try and freeze that particular asset. And on the ground, of your everyday sort of case that's not involving millions and millions in a high stakes commercial case, is just to think about how, if you're at an FDR, for example, your structure of orders is. So if you are tying in a transfer of crypto from one party to another, so that there's the equal risk reward element of holdings, that is done prior to the sale of the family home, for example, and funds don't get released from the family home until that transfer has taken place. So that if there are any issues, that the owning party refuses and breaches the order and doesn't transfer, you have recourse by virtue of there being another asset there to try and then effectively recoup and offset under obviously enforcement of variation, or arguably threat if it's not executory, in those circumstances. So it's just thinking a step ahead. But as I say, freezing injunction is a really useful tool that we have, in addition to information from judge of debtors, obviously obtaining orders for laptops themselves in the cold wallet element. Now, a little bit of story time, and I appreciate it's 12:34, so I'm just going to give you two examples of crypto cases that I have dealt with. I had a chap that knew that he had crypto on the family laptop. The family laptop was at the home with the wife, and she said she knew nothing about it. I had to argue back and forth with a judge at FDA about why it was so important that we needed this laptop to be provided to us, and we could then effectively take it to a high street IT company to assess the hard drive and just tell us what the holdings in that, and it was Ripple on that particular case, were. Wife's counsel was adamant that it was disproportionate, it was phishing, it wasn't necessary. And eventually, after trying to explain to a deputy district judge the importance of it, I think he was probably bored of my voice at that point and said, right, well, if there's nothing to hide, fine, we'll get that done. At FDR, they had spent £1,000 back on Ripple. It was worth £66,000 at FDR. So again, a really good example of sometimes dog with a bone when there is a basis for it. And also I have had a case, and one of the questions I had was, what do we look for in disclosure? Follow your gut. If there's something strange on a bank statement, inquire, make research on it. I had a variation of maintenance case in where the other side were trying to vary maintenance on the basis that his business wasn't doing very well. And we saw Swissborg on these bank statements, and we were thinking, what on earth is Swissborg? And anyway, it transpired that this chap was spending £1,000 a month on Swissborg and was still then trying to run a case whereby he was effectively saying, I haven't got the funds to pay your client the £500 a month of spousal maintenance. So cropping its head up in lots of other different examples. And finally, occupation orders, because again, we need to think slightly outside the box. I know it's not financial remedy, but again, it's a resource available to parties. Now, as I say, I could go on for ages on this, but that is my talk on crypto, a real whistle-stop tour on what is required and what we need to be thinking about. I'm always open to having chats with people about crypto. My email is there. I find the area fascinating myself, and I think it's something for us as practitioners that we need to make sure that we are really on board with, not necessarily the IT background, because that's not what we are experts in. It's how this impacts our clients and a fair resolution for their financial settlements. Now, on that conclusion, I'm now going to pass over to Rachel Bale to talk about her talk on trusts in financial remedy proceedings. Rachel is a specialist chancery trust junior barrister with a thriving practice. She is particularly good with tricky crossover matters with financial remedy and chancery matters, and she often appears in really complex matters far above her 2019 call. She's in the High Court regularly, as well as dealing with interveners in divorce proceedings, and I'm certainly looking forward to learning a heck of a lot more about trust and how we navigate that process.
Thanks very much, Laura. I hope everyone can see my PowerPoint that's up there. If not, please just pop it in the chat. That was really fascinating. And we're moving on to hopefully as fascinating a topic of trusts in financial remedies proceedings. And it's one of those areas, again, quite a novel point that does seem to pop up and is popping up more and more at the moment. And we're looking at the validity of a trust or whether it possibly is a sham and how to deal with it. So I will cover a few points today, bearing in mind the time. So we have identifying a trust, the difference between a sham and an illusory trust, and how that might be relevant, how to prove a sham, and then the more, I think probably more relevant points for most practitioners here is the procedure for dealing with trusts when they arise in financial remedy proceedings more generally, because they are coming up. They pop up in lots of different types of ways, whether it's property, whether it's bank accounts, or whether we're dealing with the more kind of complicated offshore accounts. And what pitfalls to avoid when dealing with that procedure. This is attempting to be a bit of a whistle-stop tour of trusts. It's going to be hopefully quite accessible and starting with the basics of what exactly we're talking about when we're dealing with a trust. So a lot of people get quite scared, I think, the idea of a trust fund or what is a trust when it comes to these proceedings. But really, taking it back to its bare bones. It's essentially an instrument where one party holds an asset on trust for somebody else. And there are four key players that take part in that process. So you need someone to set up the trust, that's known as a settler. You need someone to be responsible for the trust, which is known as the trustee. And the beneficiary is the person who is going to be the intended recipient. And there may be multiple beneficiaries under one trust. A protector can or cannot be there, that's not an absolute key player, but it normally is someone who's appointed to monitor or provide some sort of control or some sort of guidance over the trust, normally where it's for the benefit of a minor or someone who lacks capacity, and they might be in the background giving their guidance there. Okay, my user-friendly guide of what is a trust. So this just sets out again how this mechanism works. We've got the four key players, and when we're looking at what a trust is, we can sometimes call it a trust fund. But again, it doesn't have to be highly complicated. It can simply be that there is this bank account which is seen to be in the name of one of your clients or one of the parties, but actually they're saying it's being held on trust for mum or dad or brother or sister. And it's trying to work out and go through the line of ownership to work out who actually has control and has access to these funds, which obviously is particularly relevant when it comes to divorce proceedings. This hopefully sets out roughly how a trust works. So we have again the settler that puts into the trust fund, and then it's all moving through to the beneficiaries. In terms of trust documents, you may hear things such as trust deed, trust fund, trust document, trust letters. They're all just simply documents that are signed and executed as a deed, so signed properly and witnessed, to set out the intentions of what the trust actually is. Okay, so why do we care about trust when it comes to divorce proceedings? This all falls within the Matrimonial Causes Act, as everything does, section 25(2)(a, and we're particularly looking at any other financial resources which each of the parties to the marriage has or is likely to have in the foreseeable future. And it's that likeliness and the foreseeableness that's quite important when it comes to trust, because it's often dealing with assets that are slightly out of reach and may not be liquid now, but could become liquid down the line. The reason we care, of course, is it forms part of the computation exercise, what assets actually exist when it comes to this matrimonial pot, or if it's not the matrimonial pot, looking at each of the different assets that the parties have on their ES2 forms. And then working out, would the excluded spouse, as let's say husband is a beneficiary of a trust, wife is the excluded spouse, are they entitled to any share of that or any proportion? And what's the test where we look there? I've also mentioned about foreseeability and the timing element of this, but also what's really important is we're looking at access, not necessarily who has control, because of course a settler or a trustee will have the control of the trust. We're interested in beneficiaries and how much access they have to that money or to that property, and whether that will impact the divorce proceedings. Another case that is quite useful, and it gives this idea of how the courts approach this. It's a case of Thomas and Thomas. It's a 1995 case. And this is really sets out the tone for how the courts deal with trust. The courts will not put undue pressure on trustees to exercise their discretion in a particular way, but may frame an order which affords judicious encouragement to provide one spouse with the means to comply with the court's view of what justice is in that case. And breaking that down, essentially, there's normally multiple players when it comes to a trust. It's not often one beneficiary, there's normally multiples, there's competing interests there, and the trustee has to act in the best interest of all those beneficiaries. It is not for the court to step in too harshly and start deciding and taking over that trustee's discretion as to where these resources go. But in a case of divorce, if wife or husband is going to be left particularly out, and there seems to be a need for justice for this particular asset to be shared, they will provide encouragement to do so. I think it's quite a nice catch-all phrase when you're thinking about how the courts approach this. Identifying trust then. So what type of trust do we have? As I've said, we can have legal documents that really expressly set out that this is a trust fund or a deed of trust, and it's all a mechanism and a way of protecting assets and sharing wealth. We can also see other evidence linked to identifying what the purpose of a trust is and what a trust is used for. We can see other evidence such as the bank statements, completion statements if it's property, record of meetings, if there has been meetings amongst the trustees and the beneficiaries and what they've decided to do with the trust assets. If it is a property that takes income, for example, what kind of income they've had, the expenses and the tax pays. This goes to identifying what the purpose of the trust is, which is very important, but also how it's being used in practice. And this all boils down to what makes a valid trust, and there must be three certainties to have that. So there has to be a certainty of the intention, so it's an intention for a property, for example, or to own a property, the subject matter of what the trust is attaching to, and the object. So simply, who is it going to benefit? Who are we looking at in receiving the benefit of this trust? And if one of those three things are not clear, we may have an argument that it's not a valid trust in the first place, which is quite a handy way of working that out. Okay, moving to shams. So, what is a sham? Again, I think people get quite frightened with the terminology, but you really just need to break it down and think of it in terms of plain English language. A sham is trying to deceive. It's not real, it's pretense. And this is the key case really is again 1967 case, so quite a lot of the case law is back in the 60s on this. Letter Law Justice Diplock in Snook and London West Riding Investments states that it means an act done or documents executed by the parties to the sham which are intended by them, and I pause on intended, to give to third parties or to the court the appearance of creating rights between the parties and obligations different from the actual legal rights and obligations which the parties intend to create. And that's a key point, intention here. There has to be a common intention. So it can't just be a case that the settler knew but the trustees didn't. Both of them had to have this intention to deceive. And it's a clear, willful act to try and deceive as to what's really going on with this trust asset. It's not particularly specific to trust law, this concept. It's again common sense and general concept of law. Is someone being dishonest and trying to deceive you? Some examples of shams then, we can go through things that you may have seen that have popped up. So this is a case I had fairly recently. A husband purporting to sign over 50% shares in his company to his siblings. And what was quite interesting about that was the timing of such transfer over. It was just before divorce proceedings took place, and I'm going to talk a little bit about how we can spot some warning signs in a minute of shams. We can also see things such as wife or husband transferring beneficial interest in a property over to a family member. Often that will be for free or for a very low amount, which raises some spurious thoughts as to why they would do that and who's actually owning that property. Then we also have, this is a key case of the Midland Bank and Wyatt, where the husband created a declaration of trust, so a formalised deed, which put the matrimonial home in his wife's name and for the benefit of his wife and children. But actually the court found that this wasn't a truthful intention. What it really was a document to be used in the case of a rainy day in case creditors came knocking on his door, which he was foreseeing was going to happen. And actually the trust was an entire sham and was deemed void. Another case is an offshore case where wife set up a trust for the benefit of her family, or purported for the benefit of her family, but then she continued to control the assets as if they were her own. So in fact, she just kept using the money, she kept receiving the money, and that's the element of control and the element of deceit that we're talking about here. It's how this asset is actually being used, not what's said on paper. Okay, some key warning signs. Timing, I would say, is absolutely crucial. If you're picking up a document or finding an asset or an action such as transferring interests away, and they're just before a divorce proceedings or just before separation, alarm bells should be ringing as to why that might be the case and someone dissipating their assets or trying to hide assets before proceedings. Also some amendments, so if you knew about a trust but there's been substantial amendments to the beneficiaries or who's going to get what, that might ring some alarm bells. And then the idea of any sort of secret meeting. So there are cases where the asset is known about, the parties are aware of the trust, but then there have been these secret amendments and meetings which have substantially changed the nature of what's going on. And again, doing things quickly in a rush particularly if they're without the benefit of legal advice, would tend to raise some eyebrows as to whether this was a valid trust or indeed a sham. A very quick note on illusory trusts, because I do want to leave some time for questions. This is slightly different. Again, think about plain English, what's the power of illusion? It's where something seems real, magician doing a fantastic trick in front of you, and so the trust seems real on the face of it when you look at the wording, but it actually gives so much control and so much power to the settler that it can't ever really be deemed to be a proper trust, because they're retaining all the benefit and the beneficiary really isn't getting any sort of result from that trust asset. It's not an overly helpful description. There has been some criticism in case law of this, but just to define it a little bit more clearly, this is a New Zealand case of Clayton and Clayton. It's essentially where the settler retains such control that they never intended to actually give up or part with this asset, so broad that in fact they can just do whatever they want with the property, and that's either the settler or the trustees. Okay, so how would you prove a sham? The burden is on the party who claims that the trust is not valid, so it's always going to be your burden to bear. And the standard, of course, is the normal standard, civil standard of on the balance of probabilities plus 51%. However, this is proving fraud, essentially. You are saying that someone is misleading and being fundamentally dishonest. And the more serious the allegation, the more difficult it is to prove. And that is just a reality of running a case such as this. And I say this to say with caution that evidence is absolutely crucial, and suspicion of a sham won't be enough. You will need to have some sort of concrete evidence in terms of timing, in terms of perhaps a document that's come up giving away the intentions of the trustee, for example, to show that there is an intention to mislead. And I'll deal with that slightly more when it comes to procedure. The result, if you are able to prove a sham, is of course that trust asset is void, so it can't be relied upon, and therefore that's taken away from, well, it might put the assets back into the pot, because it actually may say, well, actually that's assets that are available for the matrimonial pot. It's not being held by husband's company, for example, and therefore I should get a claim to it. Okay, very, very quickly again, there's two main applications that you can make for dealing with shams. One is the application to set aside a transaction, a really helpful Matrimonial Causes Act application at section 37. Or you can make an insolvency application, which can be heard in the family courts or high courts, which is an application to set aside a transaction made at an undervalue. So that's really helpful if you see a property, perhaps a second property that's been in one party's sole name, that's transferred over to brother or sister for no money whatsoever, and you're starting to think, hang on, this is just simply to keep away from potential assets that we could have discussed in this divorce proceedings. So, dealing with trusts more generally, I think this is probably the most relevant. So I'll jump here. Essentially, and I put the case of Hotel 2023 case, it's really, really good. I would urge anyone to go and have a look at this if you're starting out in the trust process, because what it does is it gives a really good breakdown of the case law up until this point, and how the court should be approaching trusts, and what weight they should be approaching as to whether it's a financial resource or not. And again, it goes over a lot of the things that I've raised, the nature and the purpose of the trust, whether the husband or wife is the main principal beneficiary or whether they're perhaps a discretionary beneficiary behind a long line of others who are deemed to get this asset, how this is going to affect the other beneficiaries, and crucially, and this is the really key point, what is the history of distributions here? Have there actually been payments out every month or every year? Is there capital, liquid capital, that is getting paid and that is reasonably foreseeable to come into one of the parties' assets pot? You also want to think about the value of the pot and what the trust funds are, as I say, whether it's liquid, whether it's property, whether it's crypto assets perhaps, and the relationship with the trustees and how difficult it's going to be to get these trustees involved. And it can be quite difficult, especially if they're from different jurisdictions. Procedure then for dealing with trust in financial remedies. So you really want to start off by identifying what this trust is, what is the purpose, what is the object, what is the intention, who's going to get what, and what is it set up for. I've recently had a case where it's a family style trust set up, and it seems to be for the basis of just purchasing land, but we're also now exploring a potential honeypot of money that seems to be sat around that we weren't aware of, going through the meeting minutes and following the money that way. So what is actually the purpose here and what is being held under it? You want to be very clear on your evidence collection. So anything related to the trust documents, any letters of wishes, perhaps made from settlers that may no longer be with us or may still be with us. And again, the transactions, how is this trust being used? Are the beneficiaries getting any benefit now, or is it going to be something 10, 15 years down the line when the property is actually sold? You then want to think about dealing with the trustees. You're going to have to engage with them. You're going to have to talk about trying to get some evidence from them potentially. You may need to think about whether other beneficiaries are going to be affected by this and whether they're going to need to be brought into proceedings, especially if, for example, beneficiaries to do with the property, beneficiaries are actually living in situ. That's going to cause problems because if there's going to be any orders made with regards to this property, of course it's going to affect them. And whether this is such a big issue that it needs to be dealt with by way of preliminary hearings, and sometimes they do, especially if it's been coupled with a Section 37 set aside application. You'll need to deal with that first and what we're dealing with here when it comes to the trusts before we actually move on to dealing with the computation and division exercise of the FR process. Pleadings, right, this is absolutely crucial. If and when you get to a preliminary hearing point, or even actually, even potentially for the final hearing, normally it's only to do with preliminary hearings, but you do need to set out your pleadings. So this is in a very kind of chancery style way. You set out your points of claim and then you set out a defence, so it's very clear what your argument actually is, rather than simply relying on witness statements. They need to be done properly and raising the correct areas of law, so it's really encouraged to get counsel on board at that stage who has experience of dealing with trusts or chancery matters. Some pitfalls to avoid in this. So we have, is it worth pursuing this? And I really think this is the first question you need to ask yourself. Take a step back. What is your client actually going to gain from pursuing either a sham or saying it's a valid trust and actually it should be part of the financial resources? If we're talking minimal amounts of quantum here, it's going to be expensive and it may not be worth the time doing it. Are the trust assets material to the overall claim, for example, or are they a very small proportion of it? Liquidity is really important as well. Even if you manage to get to the point where the asset is a financial resource, how liquid is it going to be, and is it going to involve lots of different ways of getting that money out? Jurisdiction and enforcement. If the asset is maybe placed in a different jurisdiction, can you enforce the order? That's always a bit of a concern with financial remedies proceedings. And as I mentioned, third party involvement, we're going to probably have to get the trustees and the beneficiaries involved. If we're dealing with a Jersey offshore account, are they going to submit to the jurisdiction? Are they going to come to the UK and deal with this? Or are they going to fob you off, send a lot of questions, send a lot of blank responses and not be involved? So you've got to think about the cost implications. And again, it all comes back to quantum and whether it's worth it here. There may be an alternative approach, of course, if it's looking at dissipating assets. That might be an argument for add back rather than trying to go through the route of finding what the trust asset is. And the really important point here is pleadings. And come back to it. Points of claim, your defence, your witness statements when you get there, you must be consistent. And there was a question that I had before this talk, which I tried to weave in. And essentially, can you run that it's a sham and then also say, actually, it's a valid trust and my client's entitled to the assets, thank you very much. That this was raised in the case of A&A, which is a 2007 High Court case, where it was found that the wife's case was wholly contradictory because on the one hand she was saying the shares held in a family business was completely a sham run by the husband and actually it was all his own assets. And then on the same breath she was also saying they were valid trusts but she should be entitled to the share of it under the promise principle. And the wife was given very, very short shrift by Justice Mumby, as he then was, and that she hadn't even begun to make out her case of a sham, and that they were two completely contradictory pleadings. So what I would suggest in a situation like this is you need to pick a lane. It's one of those areas where pleading on the alternative is going to be very, very tricky. So you need to pick a lane. Is it a sham? Have you got enough evidence to prove a sham? Or are we going on the validity of a trust and a financial resource? And I would always suggest if you're unsure, go for the validity of a trust, because the bar is so high for a sham, and as I've said, the evidence needs to be pretty incontrovertible and not just based on this assumption, that you are more than likely to have better prospects of going down the validity of a trust route.